Thank you so much, Franz. And we will now turn to our second speaker, Ingrid Landau from Monash University. Ingrid will present the chapter she co-authored with Shelley Marshall titled Will Remedy Remain Rare? We have lots of questions. The potential of mandatory human rights due diligence to redress modern slavery. The floor is yours, Ingrid.
Great, thanks, Tamar. I'll just share my PowerPoint. Is that good?
Yeah, it's okay.
Yeah. All right, thanks. Thank you first. Thank you, Hila and Tamar, for inviting me to speak today. We'd like to also thank the editors of the book for inviting us to contribute a chapter and for all their hard work in pulling it together. It's a privilege to be part of what I think is a really rich and really important publication. So today I'm going to talk about the chapter that Shelley and I contributed, which is found in part 1 of the book on law and governance. So the starting point for our chapter is the recognition that workers who have been subject to forced labour and other forms of severe exploitation in global value chains continue to face significant obstacles in securing remedy from those who violated their rights. And this is despite international instruments on trafficking and forced labour emphasising the importance of ensuring rights holders can access remedy, and also despite the fact that remedy is now purportedly a common feature of strategies to address modern slavery adopted by nation states and multinational businesses. The obstacles to effective remedy are kind of multifarious, and they're also well documented in the literature. And I've just included 4 major kind of obstacles here in the context of global value chains. These include the kind of multi-tiered supply chains which cross multiple jurisdictions, which operate to obscure responsibility and create accountability gaps. Labour law limitations. Traditional labour law focuses on direct employment and has really struggled to capture modern slavery supply chain dynamics. Weak cross-border accountability. Again, the cross-border nature of global value chains prevents effective enforcement, and legal systems really struggle to hold parent companies liable for subsidiary or supplier conduct in other countries. And also there's, of course, procedural and cost barriers, high litigation costs, language barriers, evidentiary challenges, fear of retaliation, just some of the kind of the practical, procedural and cost barriers that prevent workers from pursuing claims and accessing remedy. Okay, so that's kind of our starting point. Our key questions kind of go to first, I guess, in Europe, mandatory human rights due diligence laws have been passed, and these really promised and are kind of understood to transform corporate accountability for labour rights harms in global value chains. These laws have already been subject to quite a lot of analysis from scholars in a range of different disciplines, but we seek in our chapter to look at an aspect of these laws which has received much less attention. So we ask, to what extent do these laws improve access to remedy for those who've been subject to forced labour and other forms of modern slavery? And we also kind of ask, well, what do our findings mean for understanding these laws as tools of corporate accountability? And more precisely here, we kind of ask, what are these laws holding companies accountable for, and to whom are they being held accountable? This is just an overview of the chapter, just because obviously I'm not going to have the time to cover it all. We contextualise and have background of modern slavery, remedy and the role of business. We provide an overview of 4 mandatory human rights due diligence laws. We compare the laws on kind of 4 bases: scope, an inclusion of remediation as a due diligence obligation, grievance mechanisms, the powers and authority of the competent of the competent supervisory bodies, which we call the competent authorities, with respect to remediation, and finally civil liability. And we'll finish with some conclusions. So to start off with, we can conceptualise modern slavery broadly, consistent with the book. The first part of our chapter discusses the international legal frameworks, articulating the respective roles of states and business to provide remedy under international human rights law. So we look at kind of very briefly at the duties on states to take measures to remedy modern slavery, and then we turn to focus on the responsibilities of businesses, in particular under the UN Guiding Principles on Business and Human Rights. Okay. So under the UNGPs and international law more generally, human rights law more generally, remedy entails counteracting or making good any harm that has occurred, and access to effective remedy has both procedural and substantive aspects. Remedy, depending on the context, may take a variety of forms. It may involve apologies, restitution, rehabilitation, financial or non-financial compensation, and punitive sanctions, criminal or administrative, as well as the prevention of harms through injunctions or guarantees of non-repetition. So that's the definition found in the UNGPs. The UNGPs also, consistent with international human rights law, emphasise the state's duty to ensure the effectiveness of domestic judicial remedies. They also make clear that states should provide effective and appropriate non-judicial remedies as part of state-based systems for remediating business-related human rights harms. More importantly, for our purposes, the UNGP set out distinct but interrelated expectations on business in relation to facilitating access to effective remedy. These include a responsibility to remediate harms that businesses have caused or contributed to, and to use the leverage to seek to prevent harms to which they're directly linked, to establish or participate in what the UNGPs call operational level grievance mechanisms, through which individuals and communities can directly lodge grievances through formalised processes at the enterprise or industry level and access remedy. And there's also responsibility on business, to cooperate with state judicial and non-judicial mechanisms. Okay, so let's go back for a sec. So these standards, particularly in the UNGPs, essentially form kind of the analytical framework for our paper. But to add further depth to our analysis, we also adopt an accountability lens, as I mentioned before, in the sense that we ask what our findings tell us about accountability relationships established under these laws. And here, drawing on Bovens, Black and MacDonald, we understand accountability as a moral or institutional relationship between different actors, in which one group or actor has an obligation to explain and justify their conduct, and another actor, a group of actors, sometimes called accountability holders, have the power to or authority to pose questions, pass judgment, and impose consequences. So with that, that's our framework. We then proceed to examine 4 mandatory human rights due diligence laws: the French law, the German law, the Norway Transparency Act, and the European Union's Corporate Sustainability Due Diligence Directive. The red text is what is not covered in the chapter because of when it was published. In the chapter, there's a recognition that political developments were going to mean that the German and European Union laws were going to change, but it's not covered in the chapter. But I still think the chapter is very useful for the analysis of both those laws. Okay. Sorry, go back for a sec. So for analysis of each law, we follow a similar structure. We cover the purpose of the law, which we think is particularly important in understanding whether it is actually supposed to be directed at preventing harm to rights holders, or just protecting business and consumers, or a combination of these purposes. We look at the coverage of the laws in terms of their scope, their material and personal scope, their reach in the supply chains, and so on. We describe the broad obligations of each of the 4 laws before turning to consider causes of action. The causes of action, the actors involved, the nature of the harm that addressed, and the entities against whom actions can be brought. We describe the array of remedies that is made available under each law, and from that we explore the outcomes that victims and survivors may anticipate. We also examine whether the laws have any access to justice provisions more broadly. Finally, to the extent that's possible, we assess the outcome of cases so far, to the extent that they shed light on the practical implications of these laws for remedy. So this is a very brief kind of comparative snapshot, which summarises some of the main kind of points of comparison. The 4 laws adopt very different approaches when looked through a remedy lens, and our discussion draws out similarities and differences between them. As I mentioned before, our comparative discussion has 4 kind of areas of focus: scope and inclusion of remediation as a due diligence obligation or grievance mechanisms, and again, the extent to which they extend to remedy as opposed to just monitoring functions, the role of competent authorities and their powers to address remedy, and civil liability. Okay. Some very kind of brief conclusions. I think there's no doubt that mandatory human rights due diligence laws represent significant advancement in corporate accountability frameworks and regulatory innovation. However, kind of our chapter shows, while it's generally presumed that remediation is for victims of modern slavery is a key focus of these laws, this is not in fact the case, and that there is significant diversity in how these laws approach the question of remedy. Our analysis kind of confirms that they're primarily directed at holding companies in the global north to account for their efforts and actions in preventing human rights harms in their own operations and their supply chains. And while this is perhaps not surprising, given that they are the focus of human rights due diligence, we do suggest that the laws, the broader understandings of these laws is that they are providing, performing a remediative role as well. So we kind of argue that remedy for victims is part of most of these laws, but it's very much a sideshow as opposed to the preventative aspect of the laws. Kind of with a deeper accountability lens, we argue that the primary accountability holders, those with the power authority to pass judgments, impose consequences, demand remediation, are regulators, civil society, consumers, and other stakeholders also in the global north. There's a real lack of provisions within mandatory human rights due diligence laws that provide direct and effective access to remedy for those, particularly in the global south, and that this kind of reinforces existing power dynamics between the global north and the global south. I want to try and finish on a more optimistic note. So we just say that it is obviously early days. There are a limited number of cases determined under these laws. But I also think that kind of we suggest in chapter, there's significant potential for kind of bargaining in the shadow of the law and other strategic uses of mandatory human rights due diligence laws to secure remedy. And indeed, I think we've seen some recent kind of developments, kind of actors using the laws to secure remedy kind of on a consensual basis with the business, with the mandatory human rights due diligence laws looming in the background. That's it. I'll stop there. Thanks, Tamar.
Thank you. Thank you so much, Ingrid. We will now turn